Hi guys, it's Kathy. I hope you're doing well. I don't know if it's like this all over, but in our town right now, like everybody is sick. Every single person is sick. I don't know what's going on. And what's going around doesn't it doesn't go away. It doesn't just hit you, knock you out and then go away. No, no, no. Everybody has been sick for a while. And it's not going away. It's very, very, very annoying. I go into work every day, and you can just hear, like, someone will cough at table 2, and then 20, and then 10, and then 5. There's, like, coughing going on everywhere. It's pretty crazy. I've not seen it like this before. But is everybody sick where you are too, Lori? I've never seen it like this. But it's February, so maybe in 10 more days we'll be better. Hi, Tammy. Alright, we're going to try to get through this stream without Micah not following the rules. Yeah, that's a mother and a daughter. And male cats, they grow up and they're cool with each other. But female cats, no, 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 no. Once the baby is old enough, mom doesn't want anything to do with that baby no more. Get away from me. All right, we are with Michael McDonald. I think. Oh wait, the jury. We might finish today. That's right. I remember now. We love you too, Tammy. Me too.
Yes.
Whereas if they could still find the guilty of count 1, it would be 1 count as opposed to 5. Why don't I work on that?
Yeah.
And then you guys can take a look at it.
Okay.
Okay? You want to work in terms of when you guys want these, I'll work on the report. Okay, great. So, I'll work on the, don't worry about this, I'll work on this. Yeah. I can email what you know to look at it. All right, I'm going to step back and work on the verdict form and the instruction regarding the determination of 5 calls, and we'll be back.
I don't have a tattoo for no other reason other than it's just so expensive and I can't let go of that cash just to put, I don't know. I have a few in mind I would love, but every time I think about it, I'm like, nah, I'd rather pay the electric.
Number 9 is back in session.
All right. Back on the record in C18-333-684-1, State of Nevada versus Michael Lee McDonald. I provided one draft of the updated verdict form, and I understood the state had an objection. Before I learned that the state had an objection, I realized that there was an issue with what I had proposed. So I modified it and created a second one. So take a moment and take a look at that, and we'll talk about why I changed it. Send it to an extra page for no reason. I apologize. All right. right, and before we finish this, I wanted to ask Mr. Mueller if Mr. McDonald was going to testify.
No, Your Honor, Mr. McDonald is, and I've consulted, and he's been advised of his right to testify, his right to remain silent, his advice of counsel that he's going to follow, he's going to remain silent. Judge, can I have the answer?
Yes. I'll give you all a chance to take a look at that. If you could put the defendant under oath, please.
Raise your right hand, please. You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, nothing but the truth, so help you God.
Okay.
Please state your name for the record.
McDonald.
Good afternoon, Mr. McDonald. Under the Constitution of the United States and the Constitution of the State of Nevada, you cannot be compelled to testify in this case. Do you understand that?
Yes, sir.
You may, at your own request, give up this right and take the witness stand and testify. If you do, you'll be subject to cross-examination by the Deputy District Attorney. And anything you say may be on direct or on cross-examination would be subject to fair comment when the Deputy District Attorney speaks to the jury in his or her final argument. Do you understand that?
Yes, sir.
If you choose not to testify, the court will not permit the Deputy District Attorney from making any comments to the jury because you have not testified. Do you understand that?
Yes, sir.
If you elect not to testify, the court will also instruct the jury, but only if your attorney specifically requests as follows. The law does not compel a defendant in a criminal case to take the stand and testify, and no presumption may be raised and no inference of any kind will be drawn from the failure of a defendant to testify. Do you have any questions about these rights?
No, sir.
You're further advised that if you have a felony conviction and it has been received that conviction in less than 10 years, or stated otherwise, that not more than 10 years has elapsed since the date you were convicted or discharged from prison, parole, or probation, whichever is later, and the defense has not sought to exclude that evidence coming before the jury, and you elect to take the stand and testify, the Deputy District Attorney, in the presence of the jury, will be permitted to ask the following questions. 1, have you been convicted of a felony? 2, what was that felony? 3, when did it happen? And that's all the questions they may ask. Do you understand that?
Yes, Judge.
I know you had another case, but I don't believe that another conviction has been entered. Mr. Mueller, is your client a convicted felon as he stands here today?
No, Your Honor, in fact, I'm drafting a motion for new trial. I hope to have on file by the end of the week.
Understood. All right. And I understand that you want to waive your right to testify. Is that correct?
I believe so, Judge.
Okay. All right. And you were making that decision after consulting with your attorney. Is that correct?
Yes, Judge.
All right. And Mr. Mueller, do you anticipate putting anyone else on the stand?
No, Your Honor.
Thank you. All right, let's go back to, you may be seated. Let's go back to the proposed verdict form. This is what I did, and I certainly welcome comment. I ended up just asking whether or not it's a separate wire communication or not. They could find it to be not a different wire communication, ultimately still find you guilty of the offenses. Then it would be an issue at sentencing of whether there's a merger or some other thing. So that's why I did it this way. I want to let you all know where my head's at, but I certainly welcome argument or suggestions from either side.
And I understand that, Your Honor. We just like a few minutes to just kind of talk.
Yes, and I, of course, would want you all to explain that to the jury as well. And then, I'm sorry, one more question for Mr. Mueller. Do you want the instruction about the defendant's decision not to testify included in the instructions?
Yes, Your Honor.
Did you include it?
I included it.
I think I did see it, just wanted to make sure. All right.
What do you need, Nicole?
And for the record, that instruction will be instruction number 11. And here are instructions for you. Do you mind one for each side? Can you put the jury in the middle, finishing up here? Thank you.
Your Honor, neither Mr. Mishler or myself had much experience with special verdict. So while we did have some concerns with verdict form version number 1, given that it led to the possible conclusion that if the jury didn't find they were separate wire communications, they could find not guilty on everything.
Correct. That's why I changed it. It didn't really give them the option to find them guilty of one count.
My initial concern with verdict form number 2 is that it was acceptable as long as the defense does not argue the problem with number 1, which is if you don't find that it was a separate phone call, but it is a phone call that was recorded by the defendant, find him guilty, not guilty of everything. The only other concern I have, so it's more of an argument, it'd be a misargument of the verdict form. But the second problem, which potentially is there, and again, this comes from lack of experience with special verdicts, is the proposed question A doesn't direct the juror to what to do if it's yes or no to B.
So if you look above count 1, it says you must answer the questions to both subsections A and B,
Okay.
because I want them to answer both questions. So it shouldn't direct them one way or the other. They need to make a determination. But I understand your concern that this potentially is an issue where if they don't find a wire communication at all, that it's not guilty. I think that's what you're arguing to me.
No, I'm just wondering if appellate-wise, the verdict is too vague at that point. I'm not sure. I mean, if it were not having those languages, it would simply say count 1, unlawful interception of wire communications, guilty of that or not guilty, and then so on and so forth. So I guess this is just as vague as that.
Well, it is just as vague, except for the fact if it's 5 separate counts, I believe you would have the option at sentencing to argue consecutive time.
I understand. So if they checked
That's why the special
yes on
finding would
one and
be,
no on the rest, and then guilty on everything, then you probably only find them guilty and sentence on one, or whatever the case may be.
it does become complicated.
It's, I guess, fine.
The alternative would be that we go back to the original verdict form, you all argue what you want to argue, running the risk that they say yes, and we have no idea if they found it to be one recording or 5 separate recordings.
Yeah, it's fine with the caveat that we wouldn't want the defense to argue. If you don't find it's a separate recording, that it's one recording, then find it not guilty and everything. That's not the spirit here. Certainly, if there's other things.
So that would be an improper argument. The argument would be for the determination as to whether or not a wire communication was made and whether it was intercepted, and if he was the one who did it, right?
Right.
So then the argument from your end would be, even if you accept that it was one communication, if you find that it was a communication, then you should at least find him guilty of count 1.
Yeah, I don't think we're going to be conceding our arguments where we're saying, oh, it's got to at least be one time guilty on one. We'll be arguing these are 5 separate phone calls, which the evidence shows.
I understand. I'm saying that that would be to
Yeah.
explain that.
Yeah, we would just probably reject if the defense made this argument.
Okay. Do you anticipate making that argument, Mr. Mueller?
They would be essentially conceding guilt on, well, no, they wouldn't be.
I'm not conceding guilt on anything, it's not guilty.
We have a problem with them conceding that it would be one continuous phone call and he's not guilty based upon this verdict.
I'm sorry, I didn't understand you, Mr. Wrong. I know, it becomes a puzzle in your head.
So if they end up conceding that this is in fact a phone call, but it was one phone call chopped into 5 pieces, and under the way this case is charged and the verdict form is read, you have to find him not guilty. If you find it as one call, we would object to that. Of everything. Not guilty of everything.
Right, because that's not how it's charged in the information. The information charges on or between a certain date range and there's 5 separate counts.
Right, and there's
Right.
specificity to what is the content of each call and their separate calls. I don't presume they'll do that, it's just our concern.
All right, Mr. Mueller, anything you would like to add?
No, you're.
All right, in light of that concern, let me just check something real quickly here. Yeah, no, no. Oh, okay, great. Oh, no, the other one. The other one. You just- Yeah.
It's smart for them to see if it comes. Officer, is there one?
We included the instruction I drafted as instruction number 7. Is everyone okay with that placement?
The state is, Your Honor.
All right, Mr.
Okay.
Mueller?
Okay.
Does the state request that we add anything to that instruction?
Might go psycho.
I'm sorry, just say that
Do you wish to add anything to that instruction?
He's on the chopping
to
block.
help explain the verdict form?
No.
All right, and Mr. Mueller, you're accepting the instruction 7 as proposed?
Yes, Judge.
Okay, all right. All right, so state, do you accept the proposed jury instructions, that I have provided you?
Yes.
And do you accept the amended verdict form?
Yes.
Mr. Mueller, same questions for you. Do you accept the proposed jury instructions?
Yes, Judge, with the reservations previously expressed on the instructions that you declined to give.
All right, and those objections are noted for the record. And do you also accept the proposed verdict form?
Yes, Judge.
All right. All right, then I think we can go ahead and grab Jay. We'll go ahead and bring the jury in.
All rise for the jury.
Thank you very much, everyone. Please be seated. Welcome back. Sorry to keep you all waiting. We were hoping to be done by 2:40, but we have a few more things to finish, and we did, in fact, finish those. So, just to be clear, I can't remember if this was stated on the record, we fully broke for lunch. State, do you rest your case?
The state rests, Your Honor.
All right. Mr. Mueller, do you anticipate calling any witnesses in your case in chief?
This case is not a defense, Judge. We will not be presenting it.
All right. And therefore, are you resting?
We will rest.
Okay. All right, ladies and gentlemen, so the jury.
Did you hear that? They're not putting on a defense. This case does not need a defense, Judge. He's not doing anything. Oh my gosh, yeah. So this can be appealed for, inept counsel.
The defendant has rested, which means we are now ready to roll into jury instructions. My judicial executive assistant, Ms. Beltran, is kind enough to stand up there and display the instructions on the television screen so you can follow along. I'll try not to talk too quickly, but you will have a copy of the instructions back in the jury room with you, so you can take a look at them. You don't just have to read them here and remember all of them, so know that. All right, let's go ahead and get started. It is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. If in these instructions any rule, direction, idea is repeated or stated in different ways, no emphasis thereon is intended by me, and that may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. Amended information is but a formal method of accusing a person of a crime and is not of itself any evidence of guilt. In this case, it is charged in amended information that on or between August 1st of 2016 and November 30th of 2016, the defendant committed the offense of unlawful interception of wire communications, category D felony, NRS 200.260, 200.690, and OC 50355. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of one or more of the offenses charged. Count 1, unlawful interception of wire communications. Did willfully, unlawfully, and knowingly All right, you know what, I'm gonna have some water. Hold on, Bob. Start again. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and/or Candace Louise by recording a phone conversation between the defendant and said Candace McDonald and/or Candace Louise without her consent, where they discussed daycare costs. Count 2, unlawful interception of wire communications. Did unlawfully and knowingly, willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and/or Candace Louise by recording a phone conversation between the defendant and said Candace McDonald and/or Candace Louise without her consent, wherein they discussed doctors, child protective services, and/or allegations of her boyfriend. Count 3, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and/or Candace Louise by recording a phone conversation between the defendant and said Candace McDonald and/or Candace Louise without her consent, wherein they discussed her new boyfriend and/or dietary needs of the children. Count 4, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and/or Candace Louise by recording a phone conversation between the defendant and said Candace McDonald and/or Candace Louise without her consent, wherein they discussed family court proceedings. Count 5, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and/or Candace Louise by recording a phone conversation between the defendant and Candace McDonald and/or Candace Louise without her consent, wherein they discuss court issues and/or dietary needs of the children. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of this case to determine whether or not the defendant is guilty of one or more of the offenses charged. Each charge and the evidence pertaining to it should be considered separately. The fact that you may find the defendant guilty or not as to one of the offenses charged should not control your verdict as to any other offense charged.
I got baby powder incense today. Baby powder incense. And it smells divine. It doesn't smell terrible. Smells like incense, and it smells like baby powder. And I just started one, and it smells so good. Go out and get some baby powder incense, guys.
To constitute the crime charged, there must exist a union or joint operation of act forbidden by law and the intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to prove motive on part of the defendant. Consider evidence of motive or lack of motive as a circumstance in the case. The defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged. A question is not evidence and may only be considered as it supplies meaning to the answer.
I've skipped a whole ba 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 ba. That's what I skipped. Now you know.
You must disregard any evidence to which an objection was sustained by the court, and any
It does
evidence
smell
that
like
was
baby
stricken or
powder
should be disregarded by
and
the court.
incense.
Anything you may have seen or heard
It's really
outside
good.
the courtroom is not evidence and must also be disregarded. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weakness of his or her
Michael, I don't think we say digits here. I'm sorry.
recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his or her testimony which is not proved by other evidence. It is a constitutional right of the defendant in a criminal trial that he may not be compelled to testify. Thus, the decision as to whether he should testify is left with the defendant on the advice of counsel and his attorney. You must not draw any inference of guilt from the fact that he does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. It is unlawful for any person to intercept or attempt to intercept a wire communication. Quote, wire communication, end quote, means the transmission of writings, signs, signals, pictures, and sounds of all kinds by wire, cable, or other similar connection between the points of origin and reception of such transmission, including all facilities and services incidental to such transmission, which facilitates and services include, amongst other things, the receipt, forwarding, and delivery of communications. Quote, intercept, end quote, is defined as the oral acquisition of contents of any wire, electronic, or oral communication through the use of electronic, mechanical, or other device, or of any sending or receiving equipment. You are instructed that the audio recording of a telephone conversation is an intercept of a wire communication. You are instructed that audio recording one's own telephone conversation without the consent of the other party to the conversation is an unlawful wire interception. Is an unlawful interception. When you're ready, I know you have to switch over to the computer.
Yes. Ladies and gentlemen, the evidence has shown that the defendant, Michael McDonald, recorded 5 phone conversations between himself and his ex-wife in October of 2016. And importantly, he did so without Candace's knowledge or consent. She didn't know these conversations were being recorded, and that's why we're here in court. Now, in every criminal case, the state is required to prove 2 things: that certain crimes were committed, and that the defendant is the person who committed those crimes. In other words, what happened and who did it. And I actually want to address number 2 first, because I can address that fairly quickly. So, who is responsible for the crimes in this case? It's the defendant, Michael McDonald. And this is not what we call an identity case. This isn't some sort of robbery in which someone was wearing a mask and we have to identify them through DNA or fingerprints or something like that. We don't have that here. So how do we know that Michael McDonald is the person who committed this crime? Well, think about it. Who else would have recorded these phone calls? We've had a lot of evidence these phone calls occurred between Candace and the defendant, and they occurred in October of 2016. And you can use your common sense. You have an instruction that tells you you can use your common sense when you're deliberating and reaching your verdict in this case. So there were only 2 people in these conversations. Okay, there's no evidence that anyone was interested in tapping anybody's phone here. That would be pure speculation. You have a jury instruction that says you're not allowed to speculate. And when you think about it, is it likely that Candace recorded these phone calls? Not really, not if you use your common sense, okay? Candace, and you get to analyze her credibility yourself, like that's entirely up to you. But if you recall her testimony, I would submit to you she seemed embarrassed just to admit that she was a Hanson fan, let alone publicize things like her daughter's rectal prolapse and other personal things of that nature. And remember, Candace admitted she was using strong language on those phone calls, the sorts of things Candace was saying and how angry she was. Ask yourself, is it likely that she would have been saying these things if she'd known she was being recorded? You also have Mark DeCiro's testimony. And even though there's a slight connection between Candace and Mark, they have one mutual friend, Mark is really more of an independent witness in this case. He's not involved in the divorce. He's interested in the law and what's going on in the case. But he and Candace, their testimony, they corroborate each other. Okay? And And you'll have the evidence with you. You'll have all of the exhibits that were admitted, and you'll see the communications between Mark DeCiro and the defendant. You'll see that the defendant just emailed him these links to these Google Drive folders, which is where the recordings were found. Okay. So this is one of your jury instructions about credibility. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weakness of his or her recollections. And so this is a case in which it'll be entirely up to you to evaluate the credibility of Candace and Mark DeCiro's testimony, as well as that of Detective Karchner. Okay, that's entirely up to you. And you'll have the recordings of the phone calls to listen to when you go back to your deliberations. Okay? And ask yourself if you found Candace to be credible. And another aspect of credibility is whether there's corroboration. And you'll remember the divorce decree in this case has been admitted as an exhibit, and you'll have that to review. A lot of what Candace was saying about what was going on in October of 2016 and her explanations of what was going on in these conversations is corroborated by what's in that divorce decree. Now, possibly your most important instruction here is your reasonable doubt instruction. Okay? A reasonable doubt is one based on reason. And the most important part here, doubt to be reasonable must be actual, not mere possibility or speculation. So what does that mean? When you're deliberating, okay, any doubt would have to be reasonable, and it can't be based on speculation. So any sort of speculation that someone tapped a phone, that someone not even related to this case tapped a phone or anything like that, that's pure speculation. Your deliberations have to involve the actual evidence, the comparison and consideration of all of the evidence that's been introduced in court, which includes the testimony that you heard on the stand, as well as all of the documents and the audio recordings that were admitted as exhibits that you'll have to review during your deliberations. That also means there's no, if you did hear some questions from defense counsel regarding whether or not the defendant went to California. You have another instruction that tells you that the questions asked by attorneys are not evidence. Okay, the answers to them are evidence, but not the questions. So any consideration along those lines would be pure speculation. Okay. Now, the crime that was committed in this case, one crime committed 5 times. It's called unlawful interception of wire communications, often commonly referred to as wiretapping, but this is the full title in Nevada. So there are 5 counts charged, 1 for each recorded phone call. As the evidence has shown, we have 5 separate phone calls here. So your first instruction regarding this charge, it is unlawful for any person to intercept or attempt to intercept any wire communication. Now, next you have a couple of technical definitions. So what is an intercept? The oral acquisition of the contents of any wire, electronic, or oral communication through the use of any electronic, mechanical, or other device, or of any sending or receiving equipment. So this is very broad. It doesn't require particular types of equipment being used to intercept that wire communication. Any sort of interception qualifies. And wire communication, I'm not even going to read this out to you. This is a very technical definition, because the next jury instruction clarifies it. The tape recording of a telephone conversation is an intercept of a wire communication. Okay? So if you believe that the defendant tape recorded these telephone conversations that you heard, and that he did so without consent or permission, then you can find the defendant guilty. And just to be clear, recording one's own telephone conversation is not legal in Nevada unless you have the consent of the other party to the conversation. And the defendant did not inform Candace that the conversations were being recorded. Now, there were some questions about the location. Because in order to be guilty of this crime, the person who is conducting the interception, who is intercepting the telephone call, needs to be located inside of Nevada. Okay? And again, you can use your common sense when you evaluate the evidence in this case, because all the evidence points to the defendant would have been in the state of Nevada. He lives in Nevada. He lived in Nevada at the time, and Candace stated she'd never known him to live anywhere else. He worked in Nevada. He worked at a company called Geotabs. He had shared custody of his children at the time, and he couldn't have just taken them out of state without informing Candace of what he was doing, and that's there in the divorce decree. And it states that right here. He would have to provide a travel itinerary indicating that he was taking the children out of the state. And we heard Malia's voice on some of the phone calls. That's why Candace says, "Hi, baby," on one of the phone calls, because Malia is with Michael, and she's doing baby babble in the background. And Candace was well aware of where he was residing at the time, and he would have been required to notify her had he relocated. And we also know that he took Malia to the doctor here in Clark County, Nevada. Clearly, there's no indication, no reasonable basis for believing that the defendant was outside the state of Nevada when he recorded these phone calls. And Candace testified that she was here in Clark County, Nevada for all of these phone calls. So this was a crime that occurred entirely inside of Nevada. Okay, so jurisdiction here has been established. Now, I want to go over some things because hopefully we didn't distract you by reviewing some of the things that happened with the divorce in this case. And the only reason that the divorce decree and other things related to the child custody arrangement between Candace and the defendant was even relevant here is because that was what was discussed on these phone calls. Okay, and had the conversations been something far more mundane and less contentious, even if they'd just been discussing movies or something completely calmly, then this would have been a very different case. And it still would have been a crime, just possibly not as emotionally charged. But that's the only reason we discussed their divorce at all and introduced the divorce decree. It's only relevant because I wanted you to understand the context of these conversations so you knew what Candace was talking about, and so you would see how she could tell when these conversations occurred, and then we could determine whether or not the defendant was here in Nevada at the time. So I hope you didn't find that as a distraction, because you're not here to determine like if one party was wronged in the divorce or anything like that, or if you agree with the child custody arrangement. Okay, it's understandable to be curious about certain things and try to work out the timeline, but all you have to consider here is whether the defendant is the person who recorded those phone calls and whether they were recorded without consent, and whether the defendant was here in Clark County, Nevada when he did so. Okay. And I want to make sure we're somewhat clear on the timeline because the order of events is important here. And I don't want you to get distracted about the YouTube video that was talked about. The order of events here is really pretty simple. Candace filed for divorce in 2015, and that divorce was finalized in October of 2016. The divorce decree was written and submitted to the court October 21st of 2016. You'll see that on the first page of that divorce decree. And eventually it was actually signed by the judge October 27th of 2016. And that's when it went into effect. And it describes the custody arrangement that they had, which allowed Michael the defendant, to see his children 2 weekends a month. Now, then in March of 2018, quite some time after these phone calls have occurred, that's when Candace is notified by Mark that these phone calls are found in the defendant's Google Drive. And around the same time,
Fletcher,
she also
thank you so much.
goes on YouTube and realizes that Michael has posted these same audio files with accompanying pictures. Nevada court watchers, people on Nevada court watchers see this. They start commenting on it and start pointing out that it's illegal to record phone calls without a person's consent. And then what happens? Well, on Michael McDonald's YouTube channel, He posts the same video, just with additional audio saying, Candace, you're being recorded, which both Candace and Mark said did not sound like it was actually part of the original conversation for a number of reasons, because the voice was in a weird monotone, it didn't match the rest of the conversation. Okay. And then Candace reports this to the police. Okay, so that's the timeline that we have in this case. And I just want you to understand that because it gives you the background for understanding the charges in this case. And eventually, those videos are removed from YouTube. Okay, that's not under our control. As the witnesses testified, it was the defendant's YouTube channel. So I submit to you that we have proven beyond a reasonable doubt that the defendant committed 5 counts of unlawful interception of wire communications. I ask that you find him guilty of all 5 counts. Thank you.
Thank you, Mr. Miller. Mr. Miller, when you're ready.
Ladies and gentlemen of the jury, not guilty on all 5 counts. There are
Maria,
so many
I
things
know
wrong
your
with this
name.
case that it's going to take a few minutes just to make a laundry list of them. But before we get to that, I want to take a few moments and talk. I want to thank you for your jury service. It's inconvenient, it's time consuming, it's time out of your days, and unfortunately, money occasionally out of your pocketbook. Thank you for being here. I want to talk a little bit about jury service. I started off as a very hard-bitten, cynical young man, and what I've learned from these experiences of standing in front of jury seats, they work very well. And the reason we have juries is because each of you on this planet have 10, 15, 20, 30, maybe more years of adult life experience. You know how people behave. You've dealt with people every single day of your life. You know what is credible and you know what is not credible. And collectively, the wisdom of you together produces a much better verdict than any one person does. So, thank you for your service. And when you come and go back, deliberate, please take your time and do a thorough job. Now, the case at hand. When you go back, I don't normally like to go, I don't want to sit here and spend a lot of time, but there is one jury instruction that I would like you to pay very close attention to, number 19 in this particular package. It says that you are to use
9 more days, I
everyday
think.
common sense and experience. We have machine fitters, we have veterans, we have businessmen, we have massage therapists. We have a very wide variety of people from a number of different backgrounds, okay? Now, when you get back there, you don't need to check into legal land. You need to use your common sense and experience and look at the evidence. Now, my colleague stood up here, and I'm going to get down to brass tacks here, and we're going to start analyzing this particular case. My colleague sat here and mumbled past the evidence. The evidence, not the feelings, not the hurt feelings, not the emotion. The evidence in this case was, just like I told you in opening statements, a busybody who had no business gets involved in somebody else's divorce case. He takes, and my colleague stood up here and she said, this case is about privacy. Remember that? Privacy was a word she used. I wrote it down. Privacy. The very first witness they put on the stand, Mr. Mark DeCiro, violates the consent to look at the Google Drive. He says, I want you to look at the YouTube videos. Maybe give me a help. He violates Mr. McDonald's privacy. He gets up here, and Mr. DeCiro didn't want to be here. You could tell by his demeanor on the witness stand, he was uncomfortable. We asked him a lot of questions and got a little heated, but that's how the truth comes out sometimes. You put people under emotion, you put them under a little stress, and they say things. Now, here's what he said. When was the recording made? I don't know. Who made the recording? I don't know. How was the recording made? I don't know. Was the recording made in the state? I don't know. That's evidence. He's the 18-year professional radio guy with expertise in editing, reformatting, and audio files. And that's what he told you. I don't know when, I don't know where, I don't know how, I don't know who. Those were his testimonies. Now, let's talk a little bit about something that was very disconcerting. There's 2 versions. They gave you one version, but he said there's another version that says this phone call is being recorded. Where's that version? Why isn't it here? What does your everyday common sense and experience tell you? If there's evidence that the state's witness tells you exists that would exculpate Mr. McDonald, but it's not here. What does that say to you? Says like maybe somebody doesn't want the truth to come out. So, that's what he said. There's another version of this. It was his opinion that it was dubbed in. So where is it? Why aren't we going to hear it? Because you're not going to get a chance to hear it. Well, all right. Let's talk about the detective. The detective gets up here, and he violates, and he admits he violates. I don't know if you saw his chagrin when I kind of asked him. I said, well, detective, isn't that the golden rule of a detective? You don't assume anything? Isn't a good detective got a little placard on your front seat of your dashboard of your car? Assume nothing? Yeah, you're right, Mr. Mueller, it is. Well, I assumed it was in Las Vegas. That's what he said. I assumed. Well, detective, who made the recordings? I don't know. How were they made? I don't know. When were they made? I don't know. That's what the detective says. That's the evidence of the case. This isn't the feelings, this isn't the passion. This is the evidence of the case. I don't know any of this. What? So I ask a very simple, straightforward question. Why don't you go talk to anybody? Well, we're afraid to go talk to people for fear that it's going to escalate things. For fear it's going to escalate things. That's why you're sitting here. Because the detective was afraid if he went and asked any questions, it was going to escalate things. Now, we're 2 witnesses into the case, and we have literally no evidence who made the recordings, when they were made, how they were made, or that Mr. McDonald made. No evidence. So the state is now 0 for 2. Then we come in, and God bless it was a long afternoon yesterday. Here's the quote. Pay me, Michael, I'll come after you. I'll call the district attorney's office. That's in there. I'm not making this up. That's the exact word she wrote. And here we stand. And there's the district attorney's office, and there's Mr. McDonald. Her anger and her bile could not be more palpable. You heard that audio tape. It was humiliating. It was embarrassing. It was heart-wrenching. You do what I want, or I'm going to wreak retribution. You're not going to see your kids. You're going to go to jail. You're going to be in trouble. Do what I'm telling you to do. Now, in your
Do what
everyday
the
common
court
sense and experience,
says.
what kind of person is that? Is that a good person? Is that a person above manipulating things to their own advice? No, it's exactly the kind of person it was. So let's talk about coincidences. When you get to a certain age in life, you stop believing in coincidences. Things don't just happen accidentally. Things kind of fall together. Now, well, yeah, I know Mr. DeCiro, and yeah, my friend works with him, and well, yeah, I guess he just kind of happened to get involved in my divorce case, and well, yeah, it was just coincidence, and yeah, it was him who got the audio tapes, yeah, just coincidence. Bull. No such thing as coincidences, and we all know that. All right, nonsense. Now, let's go through and let's see what she said that was credible. Let's see what she said that wasn't credible. We know she's animated by bile. You can hear it. You heard it in her voice. You heard it yesterday. You heard it today. Okay? Do what I want, Michael, or I'll call it this.
I can't stand this man. I cannot stand him talking. I don't want to listen to this.
District Attorney's Office. So here we stand. Well, let's go through a few things. 2 years later. 2 years later. If I reach out right now and punch somebody in the nose and then make a phone call and complain about it in the year 2022, am I really upset about that? No, I'm not. Why would I call someone 2 years later? To manipulate things to my advantage. You heard it? Mr. McDonald hasn't seen his kids. She made sure she said that. Now, 2 years later, a complaint goes out about a phone call. Now, let's look at the facts and circumstances. We know she's angry, but she said something else that was actually fascinating. Oh, yeah, Ciro's right. There are actually 2 versions. And even though one of the versions said, this call is being recorded, I too didn't find it credible because it doesn't serve my interests. Two versions. Don't you think you should have been at least allowed to hear both? Now, ladies and gentlemen of the jury, this case has many flaws. So let's use, and I'm going to calm down for a moment and get a sip of water, and let's talk about some common sense. Thanks, Mike. Don't spill, please. Thank you. Now, sometime tonight, when you get done or you take a break in deliberations, every one of you is going to call a friend or a loved one or maybe an Uber to get a ride. And the first thing you're going to say is, hello, how are you? Hey, baby, what's up? Hey, I'm on my way. Don't.
Objection, golden rule.
The answer is we all use phones.
Objection.
It's not the golden rule, Judge. It's a very simple vignette to tell people how they use phone calls to underscore the fact that 5 of the conversations don't have hellos.
It's overruled at this time.
Now, that's your everyday common sense and experience. That's how we all communicate, every one of us. Pick up the phone, you say hello. I got 5 recordings, not 1, not 2, not 3, not 4, but 5 recordings where nobody says hello. All at about the same time, all about the same subject. What does that tell you in your everyday common sense and experience? The audio tape either didn't begin at the beginning, or the word hello was removed. Or maybe all 5 of these recordings are in fact the same conversation, because one of them does in fact have goodbye. I got the old Beatles songs, I say hello, you say goodbye. We got 5 hellos, we got no hellos, I got 1 goodbye. And then I've got a redacted or a reformatted audio tape that both witnesses says contains the words, this phone call is being recorded. But at the beginning, we have no hello. Very common sense way of exploring this evidence is it was there, it was removed, the conversation chopped up into bits, and her exact words were, you pay me, Michael, or I'll come after you. That's what she said. And you'll have the audio tape back there. You listen to it. Now, the other practical problem the state's case has is they got to prove it's in Nevada. We mentioned this earlier. 50 different states, all of them have different wiretap statutes. Two-party consent, as Mr. DeCiro correctly pointed out, was a relatively recent law. The detective said these...
Why do they have to prove it's in Nevada if you just said it didn't happen? It was fudged.
These records were so old that they couldn't get verifications. I want you to understand that. They waited so long to report this that he couldn't get the mobile verifications for the phone calls.
Objection, misstates the testimony.
More respectfully, it doesn't.
The jury is going to rely on their own memory as to what the testimony was. The objection is overruled this time.
Congratulations, you threw me off my thought. Give me a second. Good job, counsel. I don't want to talk this to death, folks. This is common
Hi,
sense. We have
Walter.
some very educated, very accomplished people on this jury. We have people who know how to think. We know people who've been around for a while. And you got people how to sort things out. All right? Do you believe that Ms. Ruiz is a disinterested, dispassionate conveyor of truth and recollection, or a self-interested person? Evidence clearly. Listen to that audio tape again. There'll be no doubt. She's self-interested. Even if she doesn't intend to lie, she's very clearly coloring the facts. And even she says that, yeah, there was another version that says, you're being recorded. She can't remember Mike going to California, but that's that. DeCiro says, yeah, there was another version that says this conversation is being recorded. But I want you to understand, when you go back there, and this is very important, Not a scintilla of evidence. Not one. How about we made the conversation, recorded the conversation? Now that is what you're here to determine, not evidence. And though it is hard because you guys heard all the emotion yesterday, this is not a divorce case. It's not a divorce case. This is a criminal case. The state must prove that Mr. McDonald made recordings in the state of Nevada beyond a reasonable doubt. That is a doubt that controls the weighty affairs of life. If you can't reach that, just like we said on Monday, then the presumption of innocence favors Mr. McDonald and he's entitled to a finding of not guilty. Now, one other issue is going to come back. One other issue is going to come up in the jury room deliberation. Special verdict form. You're going to have to determine if this was even one recording or 5 recordings. So listen to it. Listen to it in total. What's jarring about this audio recordings is only one of them ends in the word goodbye. None of them end. None of them begin. That says something. Was it one recording? If it was one recording, then you can't convict them of 4. You can't convict them of 5. And then, once again, even if you find this one recording, you got to find that Mr. McDonald did it beyond a reasonable doubt. Now, please take your time, look at the jury.
Sugar, he got a point. So they don't say hello and goodbye. So that did come to be important because they have to determine if it's one phone call broken up or if it's 5 different phone calls. And without the hello and goodbye, we don't know. We don't know if it's one phone call broken up or 5 separate phone calls.
Instructions. My suggestion is read them in detail. Go to number 19, the everyday common sense, and come back and get a copy of the special verdict form.
I hate that he made a good point. It hurts me to say that.
Was number 1 and number 2? Is that a separate?
Objection, I don't think it's intentional, but that's the wrong.
Grab the one. Thank you. Okay, thank you. Go back here. First recording of separate wire communication, the answer is no. Did they prove that the case was wire intercepted that Mr. McDonald did it beyond a reasonable doubt? The answer is no, not guilty. Was audio clip number 2, is that separate recordation from the other ones? The answer is no. It doesn't begin with hello. It's pretty much a continuation of the same discussion. And has the charge been proven beyond a reasonable doubt? The answer is no, not guilty. Number 3, once again, we don't have the word hello beginning anywhere. Any indication that this was a separate time or a separate place? Is this the same wire communications? The answer is no, and therefore he's entitled, and we have not proved it beyond a reasonable doubt. He's entitled to the finding of not guilty. Number 4, unlawful wire communications. The 4th audio recording is a separate wire communication. No, this is the one that actually does end in goodbye, but it doesn't begin with a hello once again. Guilty of interception, the answer is no. Absolutely no evidence as to who actually made the recording. And number 5, unlawful intercepted wire communication. Once again, this is not a separate communications, and once again, the state has not proved the charge beyond a reason.
They tried, but the phone company said like over 2 years is too long. They don't keep that. They only keep 2 years worth of records. So they didn't have the records anymore. And yeah, he's guilty, but is he guilty for 5 or not?
Reasonable doubt, not guilty. Now, the state has, strictly speaking, done something that is strictly impermissible. They are asking you to look past the evidence and conclude who else would have made it. That's not what criminal law is about. Criminal law is about beyond a reasonable doubt, and that the state has to have some proof at all. We have no convictions. We have no confessions. We have no admissions. We have no anything. Literally. They just assumed it had to be him. And that's actually exactly what the detective said. I assumed. So ladies and gentlemen of the jury, please, when you go back there, take your time, go through it. It's a very important decision, but it is also a very easy decision. Not guilty across the board is a proper outcome. And on behalf of Mr. McDonald, thank you. Appreciate your time.
Mr. Jr. State. Rebuttal.
And then we're going to find out the verdict today. "42 minutes long for the verdict? That's crazy."
State. Rebuttal. Amanda.
Put on this mic.
Yes.
Oh, the state's rebuttal. That makes sense. My coffee's here. My coffee's here. Hi, Lizzie.
Please go.
Just hold this. Afternoon, ladies and gentlemen. It's always fun to watch a person who's been hired to represent somebody check not guilty boxes. It's like the car dealer handing you what they think you should pay and you have to pay it. Makes no sense. We're here to talk about evidence, we're here to talk about testimony, we're here to talk about facts, and these are all things that find Mr. McDonald guilty of the crimes we've charged him.
Mr. Allen, I think it's actually easier if you just turn that off. We
I would
can
love
hear
to.
you, and I confirmed with the court reporter that we can hear you, so you're good. All right, sorry to interrupt you.
Thank you very much. Ms. Mishler did start this trial talking about privacy. Now, the facts as you have them are very troubling. A woman who is in teaching for 7-8 years, been at Bonanza High School as an English teacher for about 5 years now, so during the time of these events, she was a high school teacher, encounters her divorce proceedings online. Now, that's not a crime. That's a bad thing, but not a crime. But where it does become a crime is she hears her private phone calls between the man she is divorcing being posted on a YouTube video, not once, but twice, that she did not consent to those recordings, nor know that she was being recorded. And there's a photo montage of, as you've heard from Mr. DeCiro, pictures from her home journal. A picture of her in her bra and panties. This is a high school teacher. These are private conversations, and we have laws that we this. This case has everything to do about privacy, and we have laws to protect people for when their privacy is violated. This is one of those instances. Now, the defense's claims here fail. They're trying to confuse you, and confusion is not a defense. They keep talking about, oh, there's these different versions. Everybody knows. What happens is Michael, through conversations with Mark DeCiro, gives him links to his Google Drive. One of the folders has a ton of information. Over the course of maybe a month or two, he reviews that information. Then later on, much later, Michael posts this YouTube video. Years later. And he finds that familiar. Where did I hear this stuff before? Oh, it's in Michael's Google Drive. That is not a different version. That is something that he posted. That is the privacy violation that I've talked to you about. That leads us back to the crime. The crime was not posting the YouTube video. The crime was recording the phone calls in the first place. The YouTube video makes it sting. Confusion is not a defense. He can't mismatch the facts, get you guys caught up, and then walk his guy into a not guilty. That's not how it works. Facts here are actually very easy. Now, The defendant would like you to believe that you should go to this instruction 19, which is the common sense instruction. And hell, we mentioned it, and we said you should use your common sense, and that's true. However, that is not a substitute for the beyond a reasonable doubt instruction. I've underlined these portions about don't speculate your way out of a verdict. Doubt must be actual, not mere possibility or speculation. Very important. You can't common sense your way out of the mandate under the law of the state of Nevada, and frankly in every state of this great union. This is the standard under which people are tried and found guilty or not guilty. Common sense has nothing to do with that. Common sense leads you to inferences on how to evaluate evidence. So these things are self-evident. We only presented 3 witnesses. You have a handful of things in evidence. One of them is a disc of audio, one of them is a divorce decree, a bunch of email things, some Facebook posts. But most of what is important in this case is self-evident, which means it proves itself to be true. It corroborates the statements of the witnesses you heard from. These are phone calls between Michael McDonald and Candace Ruiz. You know that because their voices are identified by the parties. They call each other Michael and Candace. They're speaking about topics that are pertinent to those 2 people. I'm not even going to dwell on it. There's no doubt it's Michael and Candace on these phone calls. They are recording of telephone calls. As much as the defense wanted you to hear, okay, it's just an audio file on a computer. They're telephone calls. Candace testified it was a telephone call, and the independent circumstances corroborate. There's distortion that you hear, that everybody in their common sense knows. The person that you're listening to over the phone, their voice is going to be distorted because it's coming through a speaker. The person who is talking in the room, their voice will not be distorted. You can tell from these calls, one party's voice is distorted, the other's isn't. But there's other interesting tells about it. The way that they're talking to each other, you can tell they're not in the same room. It's not like somebody, Candace or anybody else, surreptitiously put a phone recorder or some kind of digital recorder or even just a telephone app in the room and the conversation is going on between these 2 parties. You can tell by the content that it is a phone call. Now listen to this, it's very interesting. I'm sure that all of you have already picked up on this, but I just wanted to play this for you.
If you're somebody of doing something that is disgusting, makes me concerned.
How could you say that?
Okay.
I'm their father.
Because you're a psychopath. Who would ever suggest that? I'm telling you, all the paperwork has been here that she has a personality. She's constantly disgusting to you.
Yeah, Candace, like...
Okay, I'm not going to sit here and argue with you, but next time she has a doctor's appointment, you need to tell me. Because I'm concerned that she's not at school.
Yeah.
Like, you need to tell me that next time if she has an appointment at school or PT. Like, just don't want to necessarily tell me she has an appointment. She's not nothing to do.
Okay, listen though, Candace, like, what... Like, I just want to make sure they're safe. Like,
So obviously you can hear how tinny Candace's voice is because it's coming through a speaker. You can tell how Michael's voice is not tinny because it's not through a speaker. It's clear from that you know Michael recorded these conversations and Candace did not. It wouldn't be possible for her to make her own voice tinny if she was right there with a recorder.
Objection, facts, not evidence.
Which is a common sense argument.
That's overruled. You can continue.
The other thing that's interesting here is the quality of the audio as far as it being louder or softer moderates during this portion of a phone call. This is from phone call number, I believe, 3. What I believe that looks like is holding the recording thing closer to the phone and then somehow away from the phone and then back closer to the phone. That's how that happens. Okay, that's a recorder in the possession of Michael McDonald. Because if he was in the possession of Candace, how would it get farther from her and then come back while Michael's voice stays at the same volume? That makes no sense. So there is no notice of recording or consent given. 2 different things. You're being recorded, or I understand it being recorded. Please proceed. None of those things exist in this case. Candace testified she was not advised these calls are being recorded, nor did she give consent.
The more I think about it, the last thing I would want a jury of my peers to use if I was about to go to jail or anything is their common sense. Because really, come on, no one has common sense. And especially when you are a group of people. If it was just one person, you have a slight chance of common sense making its way. But when there's a group of people, there's no such thing as common sense. No, no, no. We need to change the whole justice system so that people do not have to use common sense because they just do not have any. Start thinking about that, guys. What can we do so that people do not have to use... I have an idea. Instead of all the juries using their common sense, they could just use our common sense. All juries now must submit their evidence to us, and we will use our common sense. Yeah, never mind. Brent's right. We're not a good. Nope. Nan. Okay. New rule. New law in America. All cases go in front of Nan. Nan decides.
She testified, and the independent facts of this show this to be true. On the recordings, there are no advisements of this is being recorded or her giving consent. She speaks in a way that is not mindful of an audience. If a person is being recorded, they would probably choose their words more carefully. She does not speak that way. She uses profanity. She is repetitive. She is emotional. She clearly did not know she was being recorded. She's going through a nasty divorce. Why would she consent to her ex or soon-to-be ex recording her? That makes no sense. And don't you think that based upon the way these conversations are going and the way that Michael doesn't seem to get the information she's telling him about taking care of the kids, that she might tell him, why don't you go back and listen to what you're recording? Because you don't get it, Michael. We don't hear that. Pretty sure you would hear that if she knew it was being recorded. Both parties were in Nevada during these calls. You heard from Candace was in Nevada during these circumstances. In fact, she told you exactly where she was during all these calls. You can hear background information that aided her in remembering exactly where she was. So the question is...
She can't make new rules because I'm going to stab her. Just said that. I just said I'm going to commit a murder on stream. I'm going to jail, guys.
Is where was Michael?
Worth it.
So, these things kind of apply to everything. He lives in Las Vegas. He worked at Geotab in Las Vegas. He has a divorce custody case in Las Vegas. But the content of the calls also help you. Content of recorded call number 1 shows Malia was with Candace when the call was made. She was leaving the daycare after finding out Michael hadn't paid on the daycare. Michael asked to see the kids, and he's offering to pay that daycare for the visitation. If he's not anywhere around Nevada, how's he going to pay that daycare? He wasn't in town, why would he be asking to see the kids? If she were to say, yes, come see them right now, how's he going to do that? That makes no sense. It took place on a weekday because she's picking up from daycare. And she only brings the kids to daycare when she's working. She only works during the weekdays. He would have been at work that day, not somewhere in California. Not had, again, no evidence of this presented anywhere, a seminar. Content of call number 2 shows Malia was with Michael when the call was made. Not allowed to leave the state with kids unless written permission 30 days prior. Never did that. So, he was here. Content shows he took the daughter to the doctor instead of the daycare, found out an appointment was canceled. Doctor's here. Therefore, he was here. Content of call number 3 shows he was in Nevada. It's the lengthiest call of the group. Over and over again, he asked to see the children. Again, wouldn't he fall flat on his face if he wasn't even here to see the children? He keeps asking, okay, Michael, come over and see the children now. Oh, sorry, I'm in Utah. I'm in California, maybe in a couple days. No, you don't hear any of that. There's no, how about when I get back, can I see the kids? It's, can I see the kids? He is here. Makes a bunch of statements about the whereabouts of Candace and the kids. It seems to sound like he knows she's not at work, even though she didn't tell him that. How would he know or care if he's not in the state? How could he figure that out from a distance? Call number 4 occurs outside the daycare facility. That was, again, testified by Candace. It was another weekday because we know it's daycare and the kids only go to daycare on the weekdays. Michael would have been working. He works in Las Vegas. He was here. Call number 5, it's a lengthier call. There's, again, no mention of him traveling or being out of town. He asked repeatedly to see the kids. Why would he ask if he's not present to see them? He was in Clark County. So ask yourselves, and this applies to everything, why would he leave the state and only then and there record phone calls? Or why would he only record and save phone calls when he's supposedly out of state? He wouldn't. Nobody does that. That makes no sense. There are plenty of clues that shows he was in Nevada during recording of these 5 phone calls. And they are, in fact, 5 different phone conversations. Defense wants you to believe, oh, it was only one that was chopped up. So, she testified it was 5 different phone calls. She gave you the context for each and every one. You heard for yourselves there are differences in circumstances throughout these phone calls. Emily is with Michael in one, and then she's with Candace in one. We know their phone calls, that's not possible. There's a progression of info on Malia's diagnoses. So it doesn't just transpire during the phone call. Oh, we think she has an allergy to gluten. Oh, she has a gluten intolerance. Oh, the physician said so. Oh, then the surgeon said so. That happens over a series of time. You have the same thing with the divorce decree, needing to be signed and then pushing forward without the signature. We have it with dating Joe, and then she's thinking of marrying Joe, which he throws a fit about because he thinks he has some kind of control over his soon-to-be ex-wife. And we have her driving a vehicle in certain conversations and then not driving a vehicle, based upon the background noise in her testimony. These are definitely 5 different phone conversations. I've already talked about it, but I want to let you listen to it again for your own. This is with regard to the divorce decree. From call number 3.
Sign the decree. I want to be divorced.
Can you let me see my kids, Candace? Like, please.
Okay.
Believe it or not. And I know you believe it, but we shouldn't be at a place where we believe this. This should be shocking to you. But there are plenty of people on Replay Crew that think this is all Candace's fault. And Michael's getting the shaft here.
Sign the decree, I want to be divorced. Call number 5.
I'm going to tell you right now, they've already submitted the decree. The court is going to sign on your behalf since you're refusing to sign. There will be nothing added.
Okay. If the divorce decree had already been submitted, why would she need him to sign the decree? These are 2 different dates. These are 2 different phone calls. That's just one example. I could play for you each and every one. Don't have to. There was no actions taken in this case of any ill intent or criminal other than Michael. No hacking evidence has been presented, even though Mr. Mueller got up and told you that this man hacked into his account. Nobody edited the content except for Michael. They were found edited in a way that was without hellos, without goodbyes in his drive. There's nothing in the law that says you have to wiretap an entire phone conversation for it to be a criminal violation. It's simply the interception and recording of a telephone conversation. Why no hellos? This is something my co-counsel actually made me interested in. After Mr. Mueller continuously said, oh, we don't hear hellos, we don't hear goodbyes. He probably didn't have his recording equipment available to him right then and there when she rang on the telephone. It probably took him a little bit to go get the recorder, turn it on, and mid-conversation start recording her. That's why you don't hear hellos. Simple as that. Makes a lot of sense. So all this bile and hatred, sure, if you forget all the context, it would be as if some kid, when I'm walking down the street, accidentally hits me in the shin with his metal softball bat. And I swear up a storm because it really hurts to get hit in the shin. and all of a sudden somebody gets up and says, that man hates children. You know, when you take out all the important stuff, sure, Candace had a lot of reasons to be angry at Michael. Clearly she had a lot of problems with the way he was taking care of the children when he did have custody of the children. So subtract all of the problems and just bring in colorful language and her disappointment and call her a manipulative person and call her somebody who had an axe to grind. But even if you did that, which you shouldn't, the evidence stands on its own. This man is clearly guilty. She could not have done anything to invent the circumstances that we have here today. Selective manipulation of the evidence is not a defense. Michael McDonald is clearly guilty of the crimes he is charged with. And this has been proven to you beyond a reasonable doubt. I ask you to find that verdict, be it take 5 minutes or 5 hours. Please do what is responsible, review, find, and convict. Thank you.
Thank you, Mr. Robin. All right, ladies and gentlemen, we're going to discharge you shortly. I do need the parties to approach the bench briefly. All right, ladies and gentlemen, so the time has come to tell you who our alternates are. Let me go ahead and let the alternates know who they are. As Tyra White and Myra Rojas. You are our alternates. You will, if you could stay behind, I'm going to chat with you briefly. The rest of you are going to head back into the jury room, but we first need to swear in both the marshal and Ms. Beltran as the alternative. They will be outside the door of your deliberation room should you meet them. So they'll be your points of contact.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into the court when they have so agreed, so help you God.
All right. At this time, the jurors who are not alternates could please follow Marshal Stanley into the jury deliberation room. Be sure to bring you those jury instructions, the verdict form, as well as the exhibits shortly. I remind you that the first thing you're supposed to do is select a four-person to begin the deliberations.
And all your notebooks, please. All rise for the jury.
I hope our Nevada judges tells us how long they deliberated. Just says verdict. There's no clock.
The jury or the 12 jurors have left the courtroom. Everyone may be at ease and sit down. Good afternoon again. Thank you so much for your service. I do pay attention, and you all have been engaged and listening, and it looks like really pay attention to the evidence. So we certainly appreciate your attention. So there are starting deliberations now. We do have one juror who's supposed to leave town tomorrow. If they do not reach a verdict before then, we will have to reach out to one of you to come in to deliberate in that person's seat. And if that were to happen, I would instruct the jury to begin the deliberations all over again.
Don't sign out. Stay.
In the process from start to finish. So I ask that you do not talk to anybody about the facts of this case until you receive a phone call from my office letting you know that a verdict has been reached, and then you would be able to discuss the facts of the case. That is, again, for the same reason I've instructed you throughout the course of this trial. We want to keep it clean. We want to keep your thoughts on the evidence in your mind, and if you're called to deliberate, to then share it with your fellow jurors, because you are required to deliberate with the jurors to reach a verdict. All right, any questions about that? Okay. I'm going to instruct the parties also not to talk to you in case we do need you to come back tomorrow or whenever they do not reach a verdict. So parties, please don't approach the alternates at this time. My judicial executive assistant has gone down to get you your juror checks. So I'm going to ask you just to sit tight for a minute, and those will be brought out to you. On behalf of the court and Park County and certainly the parties, we thank you again for your jury service. I'm sorry you don't get to deliberate, but I certainly hope you found at least the jury process interesting. So please be comfortable. If you need to use the facilities, you're welcome to step out and do so. All right? Have you provided your contact information to our clerk?
No, we will, and we have a laptop and clean mode for the jury.
Oh, yes, please do. Thank you.
You email address or phone?
Judge, do you anticipate like letting them deliberate past 5 if they want to?
It depends. So around 5, I'll check in with them and see how close they are, how far they are, and make a determination at that time. And then I'll have them come in as early as they want tomorrow. My courtroom is being used from 9 to 10 a.m. But, you know, if they want to come in at 8 to try and finish the process, I'm going to do that. So I'll give you one update. JE should be up any minute now. She just went down to the 3rd floor. All right, just about to reflect that the alternate jurors have left the courtroom. I asked you to stay just so there wasn't any questions about Mr. McDonald's status. So, all right, thank you all. We'll give you a call as soon as we have more information.
Came on in.
That's not mine. That's the courts. They gotta keep, actually got someone got a rule for. How they going on staying there, Judge?
I'm going to check in around 5 and see how close they are. If they're not anywhere close, I'll probably release them for 2 o'clock tomorrow morning. We'll call you and let you know.
All right, thank you.
Thank you.
I know how you can make her laugh, Donald.
By September 6th, you will pay $6,000 of what is due. Best interest is not, can you give her a pony?
Oh, I want a pony.
I'm going to ask the question to make sure we're being accurate with what the document says. Okay, we're back on the record in case C18333684-1. Now the record reflects the presence of the deputy attorney, Ms. Mishler, Mr. Mueller, and the defendant. I'm going to let you finish putting that time on, Mr. McDonald. Go ahead and take your time.
Good morning, Judge.
Good morning. Didn't realize I made you rush. Take a deep breath.
Mr. McDonald was held in a holding cell till 1 o'clock last night. It was more than 2. Didn't that guy need dinner, Judge?
Sorry to hear that.
We love to hear it. Say it again.
I'm confident it had to do something with our late departure last night. I apologize because the party that IJEA sent an email for the communication error, so I certainly apologize for that as well. Are you comfortable with your tie?
Yeah.
All right, want to take a deep breath?
Make it tighter.
All right.
Tighten that tie more.
So we're going to bring the jury in. I did release the juror number 3 last night. He had to catch a flight today, as you all knew, to attend a funeral across the country. So I called, or my JEA called the alternate juror last night and asked her to be here, and I understand that the alternate juror is here. So I'm going to go ahead and bring them in, instruct them on what to do, and then we'll go back to continue the deliberations.
I love my little spiders. I love when I have little spiders in the house because I know nothing else is in the house then. Spiders are going to eat it.
Oh, and counsel, I did bring some breakfast treats for the jury, just so they don't know where they're from. They're already in there, but just so you know. And then we'll have them order lunch in about an hour, hour and a half.
Oh, this is the verdict.
In
Yep.
traditional district court rule, I think it's subsection 3, that the attorneys are also supposed to give treats, and not just the jurors.
Not you. You get no treat.
Mr. Miller, you're welcome, you're welcome, I have a bowl of candy. Ms. Mishler, same for you.
Actually,
I
I've
appreciate
And there's some
that.
here too.
I believe I actually,
All rise for the jury.
I like when I see those too.
Thank you very much. Please be seated. Welcome back, ladies and gentlemen, and welcome, Ms. White. As you know, due to a scheduling issue, was made aware to the parties during jury selection process, we did have to excuse juror number 3. So he will no longer participate in deliberations. I'm instructing you now that you should continue your deliberations with the remaining jurors, adding Ms. White to that equation. However, you should not consider the opinion of our excused juror in reaching your verdict. Whatever verdict you reach, it must be the result of this jury's thoughtful and careful consideration of all the evidence. That doesn't mean that you can't perhaps discuss some of the issues that were discussed yesterday, but ultimately the verdict you reach has to include Ms. White in that process. All other previous instructions given to you will remain in effect. Give you a little bit of instruction about timing. Certainly, we're starting a little late this morning. I understand some of you got to experience the joys of the elevators. That is an ongoing issue in this courthouse. I'm glad everyone made it safely. But you will step back, begin or resume your deliberations, and we will have someone bring you menus for lunch in about an hour, hour and a half. So you won't be hungry back there. And there are also some snacks for you this morning. Any questions from the jury? All right, thank you for being back this morning, and we can step back into the jury room. Thank you very much.
All rise for the jury.
How did we get on spiders, guys? Hey, Bill's here. Please behave.
Let the record reflect that you're
Don't make me look bad in front of another content creator, guys. Try to behave. Miko, Miko, you must follow the rules right now, or Bill will think I have no control over my mods. Miko, just sit there. Just sit on your hands. Bill, maybe you could teach Miko.
jury has left the courtroom. Any questions or anything we need to put on the record for the parties?
Not
All
for the state, Your Honor.
right, thank you. Thank you for being here this
Sorry,
morning.
I'm not
We'll keep you
muted.
updated.
That's my bad.
Thank you.
DC and me would like no more spider talk. Thank you. Hi, T.
Present, Your Honor.
Thank you very much. Please be seated. Ladies and gentlemen of the jury, I understand you have chosen a foreperson. Who is that person?
I am, Your Honor.
Okay, good afternoon. Have you reached unanimous verdict in this case as to each count charged?
Yes, we have.
All right, could you please give the verdict form to the marshal? All right, the clerk will now read the verdict of the jury.
District Court, Clark County, Nevada, State of Nevada.
Thank you,
Plaintiff
Kelly.
versus Michael Lee McDonald, defendant. Case number C 333684, Department 9. Verdict. We, the jury, in the above entitled case, find the defendant Michael Lee McDonald as follows. Count 1, unlawful interception of wire communication. First audio recording is a separate wire communication from other recordings. No. Not guilty. We, the jury, in the above entitled case, find the defendant Michael Lee McDonald as follows. Count 2, unlawful interception of wire communication. The second The second audio recording is a separate wire communication from other recordings. Yes. Guilty of unlawful interception of wire communications. We, the jury, in the above entitled case, find the defendant Michael Lee McDonald as follows. Count 3. Unlawful interception of wire communications. The third audio recording is a separate wire communication from other recordings. Yes. Not guilty. We, the jury, in the above entitled case, find the defendant Michael Lee McDonald as follows. Count 4. Unlawful interception of wire communication. The fourth audio recording is a separate wire communication from other recordings. Yes. Not guilty. Count 5. Unlawful interception of wire communication. The fifth audio recording is a separate wire communication from other recordings. No. Guilty of unlawful interception of wire communication. Signed this 9th day by the jury foreperson. Ladies and gentlemen of the jury, is this your verdict? So say you one, so say you all.
Yes. All right, does either party wish to have the jury individually polled?
Yes, Your Honor, given the verdict, I think it'd be appropriate.
All right.
Juror number 1, is this your verdict as read?
Yes.
Juror number 2, is this your verdict as read?
Yes.
Juror number 3, is this your verdict as read?
Yes.
Juror number 4, oh wait a minute, 3 with, you're number 4. Juror number 5, is this your,
Oh, he's.
you're number 5.
It was that damn hello that this attorney kept bringing up, and we thought was stupid. I thought was stupid that he kept bringing it up. It was because there was no hello and goodbye.
So that's okay. Remember, we had a replacement, so we're just going to restate it. So let's just to confirm, juror number 4.
Is this your verdict as read?
Yes.
Juror number 5, is this your verdict as read?
Yes.
Juror number 6, is this your verdict as read?
Yes.
Juror number 7, is this your verdict as read?
Yes.
Juror number 8, is this your verdict as read?
Yes.
Juror number 9, is this your verdict as read?
Yes.
Juror number 10, is this your verdict as read?
Yes.
Juror number 11, is this your verdict as read?
Yes.
Juror number 12, is this your verdict as read?
Yes.
And juror number 13, is this your verdict as read?
Yes. All right, thank you. The verdict of the jury shall now be recorded in the minutes of the court.
I would be tempted
Ladies and gentlemen, on
to.
behalf of the court and the parties and your fellow citizens here in Clark County, I again thank you for your service. This was, just shy of a week, but certainly it consumes all your time, and you were here late last night, so I thank you for your diligence during the course of this trial. As I said at the beginning, jury service is one of the only ways you can truly participate in our government, and so thank you for coming and doing your service. Like I told everyone else, you are now released from service for at least 18 months, hopefully up to 3 years, at least out of Clark County. I can't make any guarantees about any other jurisdiction. So I know the marshal informed you that I will ask you to step back. I do ask you to step back. I want to personally thank each of you and chat with you for a few minutes. At the end of this, when you are released, the attorneys may want to talk to you about the case. You do not have to speak with them if you don't want to, but you are free to. The juries understand, and I will direct them that they can ask you politely if you'll talk to them. But again, you're under no obligation to do so. If you do talk to them, I ask that you be mindful of your fellow jurors and the deliberation process. So you can talk about potentially what happened, but maybe you don't want to single out anybody individually, but rather discuss the deliberations and ultimately the verdict if you so choose. So thank you again, and if we could all rise for the jury.
Does counsel want a copy of the verdict?
Yes, I do, and I'm going to formally,
Let the record reflect that the jury has left the courtroom. Mr. Lugar.
thank you, Judge, I'm going to have to formally move to set aside the verdict. Respectfully, the jury declared on 3 of the 5 counts. The other 2 counts literally is devoid of record. The conviction is based entirely on speculation, as was encouraged by my colleague when she said basically at closing, well, who else would have made the conversations? We've been through 3 witnesses, all 3 of which said they don't know who did it, don't know when it was made, they don't know the details of the call, and it's quite literally an assumption that Mr. McDonald did it. And I'm going to move to set it aside. I will submit and send written points and authorities as soon as I have a chance to prepare them.
So do you want me to rule on that motion now, or do you want to write a written motion?
Plot twist. The judge is going to set it aside.
Written points and authorities, but I'd like the record to reflect the motion is pending, and I'll support it with written
that I will allow the state to lay record and certainly supplement it if there is a written motion filed.
Thank you, Your Honor. And obviously, the state would oppose such a motion. I believe defense counsel is misstating the testimony and other evidence from this case. The only witness who actually said anything about assuming anything was the detective, who was obviously not directly involved with crime in this case. We have the testimony of two witnesses, one of which stated that he received these audio files from the defendant. The other one, Candace Ruiz, who listened to these files, and she testified that those were recordings of phone conversations that she had with the defendant, and she was not the person who recorded them. That is sufficient. Pursuant to numerous cases in front of the Nevada Supreme Court, if jurors believe the testimony of witnesses beyond a reasonable doubt, that is legally sufficient evidence. And my argument regarding who else would have made these recordings was in the context of telling the jurors that they could use their common sense and referring to them to their lawful jury instruction regarding common sense.
All right. I certainly will make a ruling on the motion as Mr. Miller has advised to be filing a written motion, and so I will wait for the written pleadings and then issue a decision upon reading the motion, any opposition, and any reply thereto. Anything else that we need to address?
Your Honor, if we could ask Mr. McDonald be released on his own recognizance. He's got almost 9 months in custody on a case that's nonviolent, that is at best confused in the middle of pleading force. Your decision won't matter, would practically matter. We still got another hearing in front of Judge Israel on the 15th.
I don't accept oral motions for release, so if you want to file a written pleading, I'll consider it at that time. That motion is denied without prejudice, pending a written pleading. Anything else?
Just the sentencing date, Your Honor.
The sentencing date. March 4th, 8:30.
And just for the court's knowledge.
Kelly for the win. Thank you, Kelly.
We don't necessarily need to.
No, that's not going to work. The law's been changed. The burglary charges are going to be dismissed out of that case. And there's several other changes at X for PSI.
Okay, well, we can go ahead and get another RPSI, that's no problem. So we'll keep that date. So March 4th, 8:30 in the morning for sentencing.
Can you just ask us my laptop?
Yes, we'll get that for you.
Great.
Thank you.
You both want a copy of this?
Sure.
Yes, if we can have one.
Appreciate all your
The
efforts.
reason why it's only 2 of 5 is because they think it was only 2 phone conversations. And the 5, they separated the conversations out. They don't feel it was 5 separate phone conversations.
Thank you very much. I appreciate everyone in the course of this trial. I'll see you all later. Thank you.
The next video is only 2 minutes long, but then the next one is 30. So we should get the sentencing, right? I don't know, whatever's in this playlist is what we're watching. I hope there's a sentencing. Alright, I'll just click it. It's only 2 minutes long, so this just might be a little bit of talking. I'm wrong. It's not.
335-284 McDonald.
Good morning, Your Honor. Karen Mishler on behalf of the city.
I apologize, Your Honor. Captain Ramsey brought over 8109. Making an appearance to take the Lewis office, who is another part of the Lewis line.
Okay, so counsel approach.
We only have 2 minutes, Judge. What are you doing?
Alright, we're gonna throw this. Hey guys, can you do this? What else? Page 2, Chang.
Hey, Buckeye girl. You should quit that job.
Yes, Your Honor. My understanding is that Mr. Mueller is in, my understanding was that he was in Henderson Justice Court.
Okay, all right.
But now I'm being informed that he's actually en route now.
Yep, and he's on his way to this court.
It's 11:20.
And we went to Anderson to handle a 10 o'clock matter, and they told him he wanted him back here, so he's here. He's in back.
Well, I did understand that, that was an hour ago. All right.
Oh no, are you kidding me? Is his attorney going to go to jail too? Remember the last time this judge with his attorney said you had better be here. You had better, and the attorney was like, well, you're going to have to figure out my schedule, Judge. Oh my gosh. This attorney is not here. But someone from his office is here. She's from his office, so maybe he won't.
We'll continue this till Monday. Mr. Mueller must be present, or we're going forward with the sentencing. If he's not, if you want to take it, so be it.
Your Honor, Monday is a holiday, right?
Oh, right, Wednesday.
Wednesday, January 22nd, 9 a.m.
My son is a
Page
Miami
24,
Dolphins fan.
Carol.
I didn't teach him that. Live in Pennsylvania. Pittsburgh. Nope. He has that teal everywhere. This has to be sentencing.
Good morning, Your Honor. Can I go back to Mr. McDonald?
335-284.
Karen Mishner on behalf of the state.
Good morning. Defendant filed supplement. Did you get your supplement?
I did, Your Honor.
Okay. I've read it all. Do you have anything to add?
Your Honor, I have taken every
By the way,
opportunity.
counsel approach.
Steelers all the way. Although I'm happy the Eagles won because I live in Pittsburgh. But oh, you're so lucky. Oh.
Your Honor, if I may address the court, and the court has been very gracious in indulging my argument on behalf of Mr. McDonald. But at this point, I'm really need to make a couple of things abundantly clear. It is the opinion of this officer of the court that these proceedings have been generated into the modern equivalent of electronic permission offer. I have screamed and complained and taken every opportunity to get this family and this political organization evicted from the courtroom. I believe Mr. McDonald has been deprived of a fair trial. With specificity and detail, number one, Detective Stanton either affirmatively lied or was so reckless in his disregard for the truth as to, in and of itself, warrant a mistrial. Specifically, Mr. Stanton said, I got an anonymous posting from Facebook, and therefore I started an investigation. Facebook does not allow anonymous postings. In fact, the postings from the website were run by Mr. Procedural and his accomplice, Mr. Schoen. Mr. Schoen is, in fact, an employee of Mr. Willick's now wife law firm. Mr. Willick personally committed perjury. I say it loudly and say it directly. I don't want to have to be there, but the fact of the matter is Mr. Willick committed perjury. He got on the witness stand and said he knew nothing about this Facebook page. He had no control over it. I have 5 witnesses who will testify just a month ago that Mr. Willick testified that he had complete control and could remove anything from Facebook and that Nevada court watches the website. Defense came in here and put on a defense argument that, in fact, Mr. McDonald is being politically railroaded in this case as a result of his association with Mr. Sampson. Mr. Willick was questioned, cross-examined, and then, when confronted with the evidence, lied. Now, he is, in fact, the mastermind behind this website. I have proof for it. I would ask for an evidentiary hearing regarding Mr. Willick's perjury under oath. Specifically, you also have the right, and statutorily, that when a defendant is being accused of crimes that are political in nature, you have under
He must be
statutory
high.
law
Must be.
175381 the right to vacate this conviction. I believe that the totality of the circumstances, the behavior of the witnesses, not necessarily personally the state, but the behavior of the witnesses is sufficient here that this conviction should in fact be vacated. Mr. McDonald, whose only crime here is to try to enact some reform over in family court, has been investigated 3 or 4 different times. I'm going to say this with a straight face, Judge. Please listen. 30 years. I've had that job. I've had this job. I've walked into this courtroom with 5 banker's boxes of criminal files as a prosecutor. I've come in here. I've done probably the most jury trials of any practitioner currently before the bar. I have never seen, I don't know of an old-timer. I don't remember when I was a kid lawyer talking to old-timers, ever seen a case where it starts with the idea, we don't like you, we're going to find something you've done wrong. We're going to try this theory first, and if it doesn't work, we're going to try that theory second. If that doesn't work, we're going to try this theory third. If that doesn't work, we're going to go forward on a prosecution. Now, this...
Oh, gosh. When you guys need to warn me when there's just... Because I can go make a sandwich. I can't listen to this guy. He's terrible. How is he allowed to just say this stuff?
Case is political, it is third world, and it is an embarrassment to the legal system. I'm asking you to vacate this conviction. It is inappropriate. I've got a non-violent first offender who's got 600 days, 613 days credit for time served right now. He's been in custody for 2 years fighting these cases. Now, this case should be vacated, the conviction should be dismissed, and Mr. McDonald should be free to go about his business pursuant to 175-381. I've got a 16-page or 18-page brief that it lays out in specificity and detail the misbehavior by the same group in the other department is sufficiently warrant I actually put an addendum in this case so you know exactly what's happened over there. So I'm going to move to set aside the conviction. If the court's disinclined to set aside the conviction, then I ask the court for a new trial. I ask that Mr. McDonald be released on his own recognizance pending a new trial. And I can't tell you how disappointed I am in this legal system on these proceedings.
Thank you, Your Honor. Your Honor, there's an old legal adage that when the law is on your side, you bang on the law. When the law is not on your side, you bang on the facts. When the facts are not on your side, you bang on the table. Defense counsel actually creatively has progressed from banging on the table and has decided when the facts are not on his side to simply make up new facts and insist that they are true despite all evidence to be contrary. And, Your Honor, pursuant to NRS 176.015, a sentence must be imposed without unreasonable delay. And there have been nothing but unreasonable delays throughout this case, all due to the actions of defense counsel. And we're now approximately 11 weeks out from a guilty verdict, and the defendant has yet to be sentenced. He was originally supposed to be sentenced on October 30th. It's been over 2 months. It's been nearly 3 months. He needs to be sentenced. And that's the motivation behind these frivolous motions. And Your Honor, I would ask defense counsel to refrain. And Your Honor, there are really three.
Oh, I want you to.
Majorly wrong
that would be
with
awesome.
Motion, both the original motion and what he referred to as an addendum. One, neither the original motion nor the addendum contains a single citation to statute or case law. Defense counsel is requesting the extreme remedy of, well, originally he was requesting a new trial, and now he's changed what he's requesting. But he's requesting that without a single citation to case law. He has not demonstrated or even referenced the appropriate legal standard that Your Honor would have to consider when granting or denying this motion. And just now, for the first time, he references NRS 175.381, which doesn't even match what he's requesting, because the motion requesting
I would officiate it.
NRS 175.381 refers to a motion for acquittal, which has to be made within 7 days of the verdict. Further, defense counsel already filed a motion under that statute several months ago, which was denied by Your Honor. And it was in that motion in which defense counsel raised these allegations regarding Detective Stanley. And those allegations regarding the so-called anonymous Facebook
Shut up,
postings were
Bren.
rejected. Defense counsel didn't even raise those in the motion before Your Honor, so that argument should just be summarily rejected. Further, the second issue with these motions is that they contain numerous false statements. And at best, they're statements that are highly suspect. And I addressed some of this in my written opposition. I don't want to go through every single thing pointing out what's factually inaccurate and what's highly suspect, because really the third issue, that's the third major problem with this motion, is that even if these absurd allegations were true, they don't form the legal basis for the granting of a new trial. And I cited the case law regarding this: Sanborn, Funches, Henney. In order to grant a new trial based upon newly discovered evidence, that evidence must be material, and it must be more than an attempt to discredit or impeach a former witness, which is exactly what this is. And furthermore, defense counsel now is completely unclear about what sort of relief he's even requesting. The motion doesn't even make clear if this is a motion for a new trial based upon newly discovered evidence. That's the only basis it could possibly be, because requesting it under on any other basis would be untimely. And nothing that defense counsel has presented falls under the category of newly discovered evidence. Defense counsel just believes he could do a better job of impeaching Mr. Willick. And overall, there have been a number of factual misrepresentations by defense counsel throughout. And what's particularly concerning to the state is the motivation behind this seems to be personal on the part of defense counsel and does not fall under the category of zealous representation of his client, Mr. McDonald. Defense counsel is clearly very unhappy with the activities of pneumatic court watchers, but that is not this court's concern. The fact that they post things that are unflattering to defense counsel is honestly none of this court's concern. Okay, they have free speech rights, which this court doesn't have the right to interfere with. And the only connection that Nevada court watchers ever had to this case is that happens to be the Facebook page that Detective Stanton was looking at when he first read an allegation of misconduct by Mr. McDonald, and that led to him initiating an investigation. Defense counsel knows that the evidence introduced at trial did not come from Nevada court watchers. Nevada court watchers had very little to do with this case. Mr. Willick was the only witness that had ever engaged in any activity on Nevada court watchers. And the state finds it highly suspect that Marshall Willick is the mastermind behind Nevada court watchers, but even if he were, it's not at all relevant. And as I pointed out in my opposition, Marshall Willick's testimony was relevant as to one specific issue relating only to the perjury counts. Because as part of the elements of perjury, the state had to prove that Mr. McDonald's testimony not only was false, but it was also material to the issue in question at that family court hearing. And that's what Mr. Willick testified about. His testimony didn't even impact the numerous other felonies for which the defendant was found guilty: burglary, forgery, offering of false filing. And defense counsel is now, he didn't even address it here, but now he's claiming that Mr. Willick is posing as someone else and on Nevada court watchers and making postings under a fake name, which seems, again, highly suspect, but again, it doesn't matter to the verdict in this case. Asking for a verdict to be overturned is an extreme remedy, and defense counsel is...
Okay, that's 2 hours, guys. Thanks for... Just kidding.
presented no legal basis for granting that. And defense counsel is not entitled to the benefit of any doubt due to the number of misstatements he's made throughout this case. Particularly on December 9th, 2019, informing this court that the defendant's mental health court application had already been submitted, when we now know, based on correspondence, it was not submitted until December 10th of 2019. And defense counsel has used the mental health court application to continuously delay these proceedings. And for that reason, his motion, the addendum to the motion, should be denied, and the sanctions should be ordered pursuant to Rule 7.60. Thank you.
Currently, doesn't answer one subject without abstaining or asking for an evidentiary hearing and telling a few asserts that I'm not willing to prove what I'm saying. I'm waiting for an evidentiary hearing to set aside this vacate or set aside the jury verdict. Additionally, my colleague has a huge post-conviction relief remedy for a new trial with post-jury trial before adjudication of guilt, which is a very different area of law. Now, this is a fresh verdict. It is substantive, has been suspect from day one. My colleague did not, cannot, and will not address the selective enforcement arguments at all.
We've dealt with that 4 times.
I know, that's why we didn't bring it up orally. Now, The answer is, Judge, this is not a verdict. I mean, I've got witnesses.
Okay, what, anything else?
Clear.
All right, denying the motion, and here's why.
Fred, you're banned.
Order to show cause?
Okay, so that takes care of one motion.
Maybe somebody could tell me what the status is.
I will stay off the sidewalks.
Any preliminary issues we need to take care of?
You will make sure that she's put on house arrest?
As you know,
That's a great question. We're about to find out.
First of all, most of the arguments that you bring up don't even deal with this case. They deal with another case in another department that has no bearing on this verdict and this particular trial. Your argument that you don't want the cameras in here has been made, I dare say, 6 times. And although, you know, I don't say I disagree that cameras are the best thing at all times. They certainly have the right, and our Supreme Court has said that that the media, and I use that in quotes, is allowed to participate in video trials. What media is, and the definition is probably for the Supreme Court, but certainly at this point, I've decided that and discussed it at least, as I said, 4 times during trial. They're allowed to videotape. What happened in the other department is really of no relevance. We have no...
Do we know 100% sure? Do we know if when he says the Supreme Court, does he mean the Supreme Court or does he mean the Supreme Court of Nevada?
Problems per se regarding that in here. For the record, I don't go on any of these websites. I don't pay attention. There are people that follow them intently.
Hi, Randy.
Okay, that's their choice. What, you know.
Gotcha.
Gossip, and I'll say that's what it is. Gossip that goes on these websites is of no relationship to this case.
No, not the next step. The judge is saying the Supreme Court says that the media can record trials. I was just wondering if they mean the Supreme Court or the Supreme Court of Nevada.
For this trial, and okay, so in addition, the other area was previously addressed in the prior motion for both a new trial and vacating or not vacating this trial, but a new trial And I believe you made the motion for, it's not a directed verdict, but in a criminal case, and that was also denied. There's been
Don't be sorry, I said it wrong. That was my bad.
Here regarding this motion, only supposition, speculation, and gossip that there is potentially something out there that would affect the one witness credibility. And of course, you raised yet again the detective's motivation for investigating what took place. There has never been anything other than the testimony that happened at the trial, which showed that Mr. McDonald.
That's the reason why I ask. If it's the Supreme Court of the United States, then maybe I can get some type of media license or some whatever media people get, and I can go and I can film New York. You guys would love New York. Just imagine Manhattan trials, or Queens, or Brooklyn. Oh my gosh.
Forged the document, and yes, you say, and you made the defense that the doctor would have done this, that, or the other thing. That all came out at the time of trial, and the jury still convicted. The perjury, the testimony in court, again, that's on videotape. His salary, etc., what he earned was verified by the witness on the stand. I find no grounds to set aside, to stay, to reschedule or schedule a hearing, or to vacate the trial. Sentencing, we're going forward with sentencing.
Thank you, Your Honor. For the record, my request for an evidentiary hearing is denied.
Yes.
All right, thank you.
State.
And Your Honor, I made a rather lengthy sentencing argument, I think on October 30th. I don't want to reiterate the entire thing. I'll just reiterate. I am asking for a prison sentence in this case. I believe a sentence of 24 to 60 months is appropriate, based largely on the fact that the defendant has demonstrated that he would not be successful on probation. He has a lot of issues with authority. Twice now he's been taken into custody in court, not just in this courtroom, but in the municipal court, and fought with the marshals who were taking him into custody. He has some issues with the corrections officers in CCEC. The records indicate a lot of arguing about whether they have the right to search him and things like that. He's not going to be compliant with his probation officer. I'm sure he will violate his probation very quickly. I don't think he's going to be a good probationer at all. I feel a prison sentence is appropriate, and with that also.
Mr. McDonald, before your attorney speaks on your behalf, is there anything you'd like to say?
Yes, Judge, if I can speak. Judge, first of all, I want to apologize to this court. This case should never came before here. I'm still being charged with double jeopardy in family court. It should have original jurisdiction there where I'm being charged for criminal contempt for that sentence. Now, Judge, I discussed with that secretary, asked her specifically for that sentence. It was approved, it was discussed. It was a clerical error. Her secretary went out of the room and forgot to add it. Then I brought it to her attention while I was on the way out. Hey, you forgot to add that sentence. She said, hey, I can't do it now. I have another client. And then I'll do it a different time. I had a new evidentiary hearing, Judge. I haven't seen my kids in almost 3 years. All these charges I have all stood from family court. I've gone nowhere near my ex. I've done everything I can through this family court just to see my children. It's very emotionally soul-ripping not to be able to see one's own children. And I swear, Judge, I had no criminal record. I used to work for the city. I'm not a criminal. I come out and have tried to reform and bring attention to what's going on in the family courts. I even went to Washington, D.C. and lobbied in Congress for the 20th Amendments of the Constitution, which is there right now, called HJ 121, SB 48, for parental rights. I've been doing whatever I can to be able to see him. I had every weekend visitation, and then unfortunately my attorney committed suicide, and I went through a terrible divorce. And now I decided to run for office to change the laws, and I get all these felony charges. Judge, I'm getting charged with burglary, 3 counts for filing a document in family court. I had no intent whatsoever to commit a felony by filing a document. My attorney, yet again, I got a new attorney, and he told me he didn't file.
Oh gosh, this is such a good fake story. Maybe we can get CJ to read it on her channel.
I felt compelled to file a pretrial memo, and I rushed it myself. I filed the document, Judge, and then I panicked. I had to do it. I had to file this document. The attorney then was dismissed. I asked Judge Marquis, hey, please, can I get another attorney? I want some time. Or this case should have been dismissed just on Rule 3.70 alone. I had an attorney record, and I filed the document. It should have been rejected. And then I get forgery charges, Judge. Now, if you look at the Attorney General opinion, forgery is the intent to alter a document, the intent to damage or defraud. I had no intent to damage or defraud. I even filed an affidavit that the secretary wrote, said she would have written it, that it was the spirit of the letter. I filed out for motion to dismiss. Then Detective Stanton's over there on Facebook. They're posting different things. And I get charged with this forgery charge. I had no intent to damage or defraud. These are my children. I haven't lost my parental rights, Judge. I've had my kids every weekend for a year till I had that trial. And then I get perjury, Judge. Perjury charges for filing a financial form disclosure that I filed all those charges. When I got out of jail, I did 6 months in city jail for trying to call my own children. I had contrary to orders saying that I could have reasonable conversations with my kids that came after the TPO order. And Judge Marquis said, you will follow my orders till further orders. Judge, all these charges, I've done my best to follow. I've never been involved in the criminal justice system before. I've just been trying to see my children. I'm a good father. I love my kids. And now to get all these felonies, I've even bailed out for $100,000, Judge. $10,000 I'll never see again. I'm out. I get right before the election, 30 days. I get thrown in. 30 days before I get thrown in jail, in city jail, and I do 8 months. I had 2 suspended sentences, and they wanted to find something against me to get to both those suspended sentences, which I had 6 months for texting my parents-in-law how to get presents to my own children. And I did 6 months on domestic violence where she said that I pushed her to custody shame. I never touched her, Judge, whatsoever. All these charges, it's complete nepotism. I've done everything I can to bring forth to be able to see my kids and then to get charged with all this. I get out of jail in April. Finally, after 8 months, I go and I'm ministering to the inmates. I help form I'm a director of a nonprofit out here working on the homeless situation with the courtyard, with Mayor Goodman and Councilman Kaufman. And then I'm out projecting that. We're about to get some grant money and help with that situation. And then I send presents to my kids on Father's Day, 6/16. It was my son's 8th birthday. There was no order saying I couldn't send presents to my children, Judge. And then my ex files a TPO because of presents. The DA, Ms. Mishler, then files a motion to revoke my electronic monitoring. And I get 3 times, you yourself even said, I don't see any order saying he can't send presents to his kids. Then Kathy Hardcastle, who also filled in my divorce case when Marquis went on maternity leave, goes and says, I remember you, Mr. McDonald. We're going to throws me in jail for sending the presents, Judge. I go before thank God I got a new judge, Judge Moss in family court. And she goes and says, yeah, there was no order, but here, we're going to put it on, we're going to put this TPO just as caution. And then I go and I've spent, the last 6 months in jail now, Judge. I don't understand the legal system, Judge. I don't understand how justice can be served. I've done more time than the majority of people in here. I've talked to thousands of people's cases. I'm the jailhouse lawyer here. And I can tell you what, I've never seen so many cases that have been, I've seen complete nepotism in our system. People getting jail and prison sentences. How is that going to reform a man? To give them prison it doesn't help them. They lose their job, their car, their kids, their house, everything. So Judge, I ask that you please acquit these charges. To get burglary for filing a document, all these charges should have been brought through. I've done enough time, Judge. I just want to get out and get back into life, focus on the nonprofit that I'm a director of. I know a lot of people out here, a lot of good people, and we're working on change. And I hope, yeah, change is slow. I mean, even the spirit of Martin Luther King that just happened on Monday. I mean, he had a dream, and Judge, I have a vision to keep families together. I believe that's the root cause of so many social issues: anxiety, depression, mental illness, criminal history, drug use, sex trafficking, mass shootings, all occurring because of breakdown of our family. And I tell you, Judge,
Oh, he's an ass. He's a total ass.
Divorce. I'm the kind of guy that wouldn't have gone through a divorce. And I was alienated when I was 5 from my father. And it especially hit me because I saw him a handful of times growing up. And I know the feeling of having anxiety and having depression growing up because of that. And I didn't want my children to have to go through the same thing. So Judge, I asked that, yes, I was emotional, I did some stupid things, but I ask that you please quit these charges and let me move about my life and go back and take the proper steps through family court. I'm a lot more educated and more experienced. I can tell you I didn't have all this gray hair before I came into jail as well. So please, Judge, please acquit these charges. I ask for grace and mercy and ask that this to be dismissed and so I can move on with my life and eventually be able to see my children and be there again. Thank you.
Mr. Mueller, do you?
I've never seen the district attorney office try to intervene in a divorce case before. There's no mechanism for that to happen here. Now, having said that, Mr. McDonald was a single-minded man who was a dedicated parent. He clearly was devastated by the divorce. He got 615 days credit for term served. My colleague will never see this case again. We will never see another case like this again. There's absolutely no need for an additional prison sentence. I'd ask for preventive probation, Judge. He'll do just fine. And in fact, if we put him in prison, he'll be out almost immediately. The state will actually not be as well served as if he got probation, which he will at least be monitored on.
Thank you.
And Your Honor, I just want to say the defendant has 200 days credit.
I hereby adjudicate you guilty of counts 1, 4, 9, burglary, 2, 5, and 10, forgery. Count 3 was not guilty. Count 6, perjury, 7 and 11, offering false instruments, and count 8, perjury. I assess you the $25 administrative assessment. DNA was, I believe, DNA was not taken until now, so DNA at 150, DNA administrative assessment of $3. Mr. McDonald, the two most serious things are certainly the forgery of the letter from a healthcare, I believe she was a psychologist, who testified on the stand. And there was, my recollection, additional requirements that she would have put in the letter, which are important. You can't just make up your own letter and say, well, she generally would have done that. And second of all, and equally, if not more importantly, this wasn't a case where you testified, I make $12 an hour and you really made $15 an hour. You testified under oath that you didn't have any income, and you totally are ignoring that. You want me to, once again, throw out the charges. I assume that was your request. When the videotape from the case was clear on its face. And these things matter to your children. And yes, I'm sympathetic that you have not had visitation, etc. But on the other hand, a crucial part of that is ordering child support, and you flaunted that basically thumbed your nose. And so those matters, and the jury agreed, found you guilty on those. Not on the one, they took every one individually. Count 3 you were acquitted of. They considered all of this. I hereby sentence you to 12 to 34 on counts 1, 4, and 9. Count 2, I sentence you to count 2. I sentence you to 12 to 34. Count 5 and 10, 12 to 34. Those counts 2, 5, and 10, 9, and 4 are running concurrent to count 1. Count 6, 12 to 34, again concurrent. 7 and 11, 12 to 34, concurrent. Count 8, 12 to 34, consecutive to count 1. The aggregate will be 24 to 68. And
months. 24 to 68 months.
Credit of 200 days.
Yeah, it's not correct, Judge. So got the PSI prepared. It's document 533 is our.
Your Honor, defense counsel is looking at the original PSI. They were informed, and I provided counsel with a copy of the updated PSI, which showed the correct amount. I believe they show approximately 156 days as of October 30th.
They showed 600 days when he wasn't, it was impossible.
Actually, I had him remanded concurrent when he was doing the city jail time. I put it on counter and remanded him on this case. He's actually, I believe he's entitled to that credit.
The original PSI calculated that they mistakenly thought he'd been in custody the entire time of the case, and obviously that was not the case. Otherwise, I wouldn't have filed a motion to remand him. He was out of custody for a significant portion of this case.
He gets credit when he was remanded, but not for, not since this case was originated, he wasn't in custody. You don't agree on the 200?
No, sir.
Then show me where it's.
All right, I'll put it on, I'll get the whole paperwork and count it out. But it is, I've got the PSI, I remember very specifically walking in and getting him remanded. That he sat in custody for that part of a year on this case.
All right, we'll bring him back on Monday for the credit for time served.
All right, thank you, Judge.
January 27th, 9 a.m.
Correct.
So you're not ordering the 200?
No. We'll hold on from the JSC until Monday. Everything else is done.
Judge, can I
See you? No, we're done.
Pages 5 and 6.
I'm just going to go through the 5-minute one just to see if they go through the credit for time served. It's just 5 more minutes.
This is just a continuation regarding his credit.
That's correct, Judge. Mr. I calculated it, and I gave it to the lawyer, my office calculated right up, we both came up with the same conclusion, 622 days is correct.
Go ahead. I saw your memo. I don't understand how he gets credit while he's in custody on another charge. He wasn't indicted until October, what was it, 3rd? Yeah, 3rd on this charge. How does he get credit?
The same underlying case. The state changes the theory of liability, or changes the spelling, and it issues that information.
Well, we'll hear from them, but I didn't think that had anything to do really with this.
Same case, but
Thank you, Your Honor. So I think P&P has some issues calculating credit for time served, because what happened in this case was initially the case originated in justice court, and then I eventually did a superseding indictment. So my calculation for credit for time served as of today is 215 days. He originally had his initial appearance in justice court on May 16th of 2018, and he was released on electronic monitoring on May 25th of 2018. So he has 10 days for that. And he was out of custody. He was out of custody at the prelim in this case. On September 25th of 2018, he was remanded in a municipal court case, but not in this case. And that was the case he didn't have arraignment. It was repeatedly stated on the record that he was in custody on a different case, but not in this case. Defense counsel did have him remanded on April 14th of 2019, and that's reflected on his scope. Obviously, he wasn't in custody before that, otherwise why would he be remanded on April 14th of 2019? And then on April 28th of 2019, he was released in this case by Your Honor's ruling on electronic monitoring. So he gets 15 days for that. And then he remained out of custody until July 22nd of 2019, and he was remanded in custody here in his courtroom after I filed a motion to revoke his custody. So that's the majority of his credit. He gets 190 days credit for that, which adds up to 215 days total.
my colleague then concedes that he was remanded in custody in this case on April 14th, which means at the minutes he was remanded for Trump. He was entitled to all that credit, which is exactly what I put in the calendar. In fact, I don't have recollection of much of anything, but I specifically recollected because I had a hard time convincing you to release him. I was actually he's got 622 days credit. I stand by those calculations. Now, preparing for another trial this weekend, he said that I've got 102 different lawyers look at it. We'll come up with 622 days.
He wasn't in on this case on May 16th. And he went in on this case on what date?
April 14th of 2019, and then was released on electronic monitoring on April 28th of 2019. And then he was remanded again on July 22nd of 2019.
According with your request for 622 days, correct?
It's the calculation for P&P as well.
2 years, 2 years back from today wouldn't even be right.
You're back from today would be 740. Yeah, it would be.
And he hasn't been in custody the entire time on this case. So that's why I just don't get it. What you're saying that somehow he should get credit on the case that he was being held in the other.
On motion, you remanded him on pro tonque. I put it on calendar, asked the court to have him remanded on the case. He got remanded, he got 6 more months of credit on this case. Now he's entitled to.
The Justice Court case was to a lower level. I just don't agree. 215 days credit.
That's plain error, thank you, Judge.
Thank you.
That's fine. Mike, stop. The appeal will be on file today, okay? Thank you, Your Honor.
Page 14, Garvin Smith.
I filed a motion that you.
Your counsel has spoken. File it.
I did it.
330720, Mr. Bowman.
Good morning, Your Honor. James for Mr. Smith, who's present in custody.
I remember that. I remember that. That was awesome.
Where these people came into court, violated.
That is for tomorrow. Guys, thank you so much for coming out today. We finally made it to the sentencing of that 2 to 5 years. I don't know if he's still in jail. I have no idea. And it looks like we're going to wrap up this tomorrow. It looks like we have a few more tiny clips to watch, and then we're done with this tomorrow, and we go back to regular old clips again. Yes, OJ. You're not babysitting your... Oh, I'm sorry. Good night, Lacey. Thank you so much, mods. Thank you for all you do. Maiko, you do a fan-freaking-tastic job every single day. I don't even know if you ever take a day off. You're like the rock of so many channels, and we don't appreciate you enough. But thank you all, mods. Kelly, thank you everybody. I appreciate it. I will see you all again in, I don't know, 2 minutes. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late at night, when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh